What are letters of marque and reprisal? Have you ever wondered how governments historically authorized private citizens to engage in acts of war? This brings us to the fascinating concept of letters of marque and reprisal. These are licenses issued by governments that allow private individuals or ships, known as privateers, to attack and capture enemy vessels. Essentially, they deputize private citizens to act in wartime, making it legal for them to seize enemy ships and their cargo. The idea of letters of marque dates back to medieval times, with the first formal examples appearing in England in the late 13th century. A letter of marque gives a private shipowner permission to outfit a vessel for warlike activities against enemy commerce. This approach allows a nation to supplement its naval power without incurring direct government expenses. Alongside the letter of marque is the letter of reprisal. This document specifically authorizes the holder to seek restitution for losses caused by foreign parties when normal legal remedies are unavailable. Together, these letters enable private parties to conduct what could be termed a private war against enemy nations. The spoils from captured ships were often shared between the privateers and the government that issued the letters. Historically, letters of marque were significant during times like the Age of Sail and the American Revolutionary War. They provided a cost-effective way for governments to disrupt enemy trade and support their military efforts. Privateers, operating under these commissions, contributed to national defense by attacking enemy shipping while being allowed to keep captured goods as compensation. From a libertarian viewpoint, letters of marque and reprisal highlight an interesting blend of private initiative and state authorization in matters of war and defense. Libertarianism advocates for limited government and non-interventionism, suggesting that war should be declared constitutionally with public accountability. The United States Constitution grants Congress the power to issue letters of marque and reprisal, reflecting a constitutional mechanism for involving private actors in national defense under strict legal authority. However, libertarians generally prefer a non-interventionist foreign policy, cautioning against expansive military actions. The use of letters of marque aligns with a decentralized approach to defense, potentially reducing the need for large standing navies by utilizing private enterprise. Yet, libertarians stress that such powers must be exercised with constitutional oversight and only in defense of legitimate national interests, steering clear of unnecessary foreign entanglements. In modern times, the practice of issuing letters of marque has largely fallen out of use. International agreements, like the 1856 Paris Declaration respecting maritime law, have formally banned it, although the United States respects this agreement even though it has not signed it. The U.S. retains the constitutional authority to issue such letters but has not done so for over 200 years. Letters of marque and reprisal are historical legal instruments that authorized private citizens to act on behalf of their government in maritime conflict during wartime. They illustrate a constitutional power designed to balance state authority and private initiative in national defense, resonating with libertarian principles of limited government and constitutional war powers.